Hello and welcome to this webinar on the patentability of diagnostics. The focus of this webinar is going to be diagnostic methods in particular and the subject matter eligibility issues that they face in the US, in Canada and at the EPO. My name is Philip Price. I'm a European and UK patent attorney at Dehns in the UK, and I'm very pleased to be joined by experts from the US and Canada for this discussion. Our first speaker today is Lisa Mueller, who is a patent attorney and partner at Casimir Jones in the US. And our second speaker is Noel Courage, patent attorney and partner at Bereskin Parr in Canada. Lisa and Noel are both well-known presenters on biotech IP issues and are very highly regarded practitioners. So first of all, I'd like to thank Lisa and Noel for taking the time out today to speak with us. I should mention how questions are going to work for this webinar because this is a recording. We weren't able to do a live screening because the speakers and the audience are spread across so many different time zones. There wasn't one time where we were all awake. So we can't answer questions during the webinar itself, but we are very happy to do so afterwards. There are two ways you can send questions to us. Either send them by email, and our email addresses will be on the final slide. Or I'm told that if you submit questions through the Zoom question and answer button, we are able to pick those up somehow, even though this is a recording, and either way we will respond to any questions we receive. One final piece of housekeeping before I hand over to Lisa. Lisa, Noel and I have previously collaborated on a book called Global Patent Protection and Enforcement of In Vitro Diagnostic Inventions. The book covers the patentability situation for diagnostics in 9 jurisdictions, the US, Canada and Europe, also China, India, Japan, Russia, Australia and South Africa. You'll find a link to that book in your registration emails, and I'm sure one will be sent out with the slides on the recording. Lisa edited and compiled this book, which was a huge task, as well as writing the chapter on the US situation. So I imagine a lot of people are tuning in because of the situation in the US at the moment, maybe hoping to get some pearls of wisdom for overcoming the 101 objections that we're facing on our diagnostic cases. So Lisa is perfectly placed to help us out with that. I'm very pleased to hand over to her now. So over to you, Lisa.
Well, thank you very much, Phil. Well, again, thank you everyone for joining us today. As Phil mentioned, I'm going to talk about the patentability of diagnostic inventions in the US. So just a quick roadmap of what I'm going to talk about today. I'm going to start off with the basics, just a little refresher on subject matter eligibility in the US. I'm going to start off looking at the statutory categories of subject matter that are created by Section 101 of the patent law. And then I'm going to look at judicially created exceptions to Section 101. Then we're going to focus in on the US Supreme Court decisions that have led us to where we are today and the difficulties with patenting diagnostic inventions in the US. And then the result of those decisions is the current 2-step framework for eligibility that both the USPTO and the courts use when evaluating subject matter eligibility. And then the rest of the time, we're going to talk about the current state of affairs, talk about claim strategies, and then finally look at some very recently issued US patents directed to diagnostic inventions. What you'll see is, while challenging, you can get claims through the US. You just are going to end up having pretty specific and somewhat narrow claim coverage. So with that in mind, let's just focus a little bit and just briefly on the basics of subject matter eligibility here in the US. And essentially, our provisions on subject matter eligibility come from Section 101. And this section sets forth the various, what we call statutory categories of patent eligible subject matter. And that's basically a process, a machine, a manufacturer, or composition of matter, or any new and useful improvement of any of those. And this has pretty much been the language that we have used in the US ever since our very first Patent Act in 1790. It's been tweaked a little bit, but one of the things you'll notice is that this language of this statute is very, very broad. It's very inclusive and doesn't have any real exclusions. And because of that, that's where our Supreme Court has come in. And they have said that Section 101, while extremely broad, is overly broad. And therefore, there needs to be some exceptions. And these exceptions that the judges have created over time are what we call judicially created exceptions. And they fall into three buckets. The first bucket is a law of nature. So something like the law of thermodynamics, the law of gravity, as you see here, Sir Isaac Newton getting bonked on the head by an apple. Those things are considered statutory ineligible subject matter. The next bucket is natural products. Really anything available out in nature, whether it's a rock or a plant, and as we'll see shortly, whether it's isolated DNA or proteins, are all considered natural products that should be available for everyone to use and are not patentable. And then finally, our third category, and probably the one that's a little challenging for people to understand, is abstract ideas. And you might be wondering, well, what is an abstract idea? And that's a really good question, and something that our courts are still trying to figure out and still struggling with right now. But generally, what I can tell you is some of the categories our courts have found, or ideas and things they have found to constitute abstract ideas. And these have included things such as mathematical concepts, things like mathematical formulas or equations, certain methods of organizing human activity, or fundamental economic principles or practices like hedging risk. And then finally, anything that involves a mental process, whether anything that's processed by the mind, whether it's something related to observing something, evaluating something, or making a correlation between something, is all considered to constitute an abstract idea. Now, one of the seminal Supreme Court decisions in the area of subject matter eligibility came around in 1980, and this involved the Diamond versus Chakaberry case. And in this case, Dr. Chakaberry, who worked for General Electric, came up with a genetically modified organism that was useful for cleaning up oil spills. So tremendous value and potential for that invention. Both the U.S. PTO and the Board of Patent Appeals rejected Dr. Chakaberry's application, saying that genetically living organisms were not patentable subject matter. And the case made its way all the way up to the U.S. Supreme Court. And the Supreme Court, I think in a little bit of foreshadowing, in a 5-4 decision, basically said that the subject matter, these genetically engineered organisms, were patent eligible subject matter. And they specifically came up with this quote that's been cited repeatedly over time, that essentially patent eligible subject matter includes anything under the sun made by man. Now, practitioners such as myself, after that decision, really didn't worry too much about subject matter eligibility in the life science space. We thought it was pretty much resolved, and one of those issues we didn't really have to concern ourselves. But however, beginning in 2012, we had 3 consecutive years of U.S. Supreme Court decisions that significantly changed the law on subject matter eligibility. And these were the Mayo case in 2012, the Myriad case in 2013, and then finally the Alice case in 2014. And each of those cases dealt with one of the judicial exceptions. The very first case, the Mayo case, was directed to optimizing a drug treatment protocol where you administer a drug, you look and measure levels of the metabolite of that drug, and then depending on the levels, you either increased or decreased the dosage of the drug. And basically what the Supreme Court said in that decision is that measuring those levels of a metabolite of a drug is pretty much routine and conventional. And once you administer a drug, whatever the level of that drug is in the bloodstream is a natural phenomenon, a law of nature. So really correlating and deciding whether to adjust the dosage really doesn't transform that in any way. So therefore the claim was invalid for lacking subject matter eligibility. The next case, the Myriad case, was directed to the isolated in DNA of the BRCA1 and BRCA2 genes. And here the Supreme Court very simply said that taking DNA or proteins out of their natural environment using standard routine isolation techniques, which have been around for quite a number of years, really didn't change the composition of those products as they referred to them. Therefore, there was no significant transformation of those products. Therefore, they constituted ineligible subject matter. And then finally, the Alice case was our abstract idea case. And this was directed to a computer implemented method for mitigating settlement risks. And again, the same thing. There was nothing in the claim here that significantly transformed this abstract idea of hedging risk. So therefore, the patent was invalid for lack of subject matter eligibility. So the upshot and result of these three cases was a two-step test that the Supreme Court articulated by the time we got to Alice. And that two-step framework is now what's used to determine subject matter eligibility, both by the courts and by the USPTO. So let's take a look at that two-step test in more detail. Now, this test starts off pretty straightforward, in a pretty straightforward manner. The first step involves looking at the statutory categories of invention that are recited in Section 101. And really, 9.9 times out of 10, this isn't a problem. So essentially, is your claim directed to a process, a machine, a manufacturer, or composition of matter? So that generally is not a problem. And if it is, you're pretty much stopped at the outset at the PTO. So then you move to the second step. And step two, under this two-part framework, actually has two subsets within it. Step 2A is what we call the judicial exception step. And that's looking at your claim to see whether it recites a law of nature, a natural phenomenon, or an abstract idea. And quite frankly, for diagnostic inventions, I do a lot of them. 9.9 times out of 10, there usually is some either law of nature, natural phenomenon, or abstract idea recited in those claims. And if that's the case, you move to the second part of step 2, step 2B, and this is what we refer to as looking for the inventive concept. And what the Supreme Court has said is it's okay if your claim recites a law of nature, a natural phenomenon, or an abstract idea, but you have to include other elements and features in there that are a practical application and significantly transform that law of nature, natural product, or abstract idea into something significantly more. And so that's where we struggle and where the big debate is now in the US. And we'll talk a little bit more about that here in a second. So again, as we saw in going through that two-step framework, if you have a judicial exception recited in your claim, which if you're practicing in the diagnostic area, and you're certainly going to have, most likely have that in your claim, you're going to have to add something significantly more to make that claim patent eligible. The key with this concept of adding something significantly more is that it can be anything that is not routine or conventional. It doesn't have to be new. It doesn't have to be inventive on its own, but it has to be something that's not routinely known by those skilled in the art in order to confer patent eligibility. And we'll take a look at that here in a second. So in terms of claim strategies, to have success in getting patents through the USPTO and surviving litigation in our courts, there's a couple things you should consider when you're drafting your applications and when you're prosecuting them. First of all, one particular strategy you can use is simply take the judicial exception out of your claim. And we'll see that here in a second, that a lot of times the examiners will recommend that you just do exactly that and take the judicial exception out. Other things you can do is add a specific type of detection device. Maybe you're using a mass spec, for example. You can add that into your claims. A particular type of technique for detecting a biological sample or a reagent or a primer or probe, something like that. Or a specific sample type. Maybe you're using a stool or saliva, adding more specificity to your claim. Additionally, if you have a novel way of measuring a biomarker, maybe you're using a new assay, or let's say you have new reagents, you have brand new antibodies, you might have a new label. All those types of things are very, very helpful in getting over a 101 rejection and showing significantly more. Another way you can revise and draft your claims is including unique combinations and panels and numbers of biomarkers. This is also very helpful in getting over a 101 rejection and avoiding a 101 rejection where you have a minimum number of markers that are required for use in the particular claim. Now, a very popular way of overcoming a 101 rejection in a diagnostic claim is to add a method of treatment step. And that method of treatment step within the claim is tied to the diagnostic step. One word of caution with adding treatment steps is your treatment has to be somewhat particular to your diagnosis step. And then you also have to be on the watch for divided infringement issues, because a lot of times the entity performing the diagnostic step is different than the entity that's performing the treatment step. And that can be problematic when you're trying to enforce these types of patents with these treatment limitations. And then finally, I think one of the things you'll see here in a second when we dive into some of the patents that are currently issuing in this space in the US is you're typically going to have to include combinations of these strategies in order to get your claims through. And what you'll see here in a second is a lot of the claims that are currently issuing in the US are very specific and have a lot of limitations in them. So by way of example, this first patent that was issued earlier this year in March, you'll notice it's directed to a method, and the method is for extracting genomic DNA from an individual who's suspected of precancer or colorectal cancer. And you'll notice that the biological sample used here is a stool sample. You'll notice in the second part of the method here that we have an amplification step where you're amplifying genomic DNA with primers that are specific for KRAS, and then measuring the KRAS mutation by performing certain techniques. And you'll see digital melt, curve analysis, or quantitative allele specific PCR. Then treat the extracted genomic DNA with a bisulfite, then amplifying that bisulfite treated genomic DNA with primers specific for BMP3, and then measuring methylation levels by using some specific techniques. So right off the bat, you'll notice this claim is just directed to a method comprising. There's no recitation of anything else in this claim or in the preamble for that matter. So you'll notice the claim specifically lacks the judicial exception. You'll also notice that it's directed to a specific biological sample type, a stool sample. And then you'll notice that it also talks about amplifying the bisulfite treated genomic DNA with very specific primers. And then it also talks about measuring the mutation and methylation levels using very specific techniques. So you can see here an example of putting a lot of specificity in your claim to show that you've transformed what probably had a judicial exception in there to begin with into something significantly more. Next example, a patent that just issued last month. This is an example of a case where you can get a relatively broad diagnostic claim where you're using a panel of markers. So here, the method is for measuring a panel of biomarkers in a subject that's suspected of having breast cancer by obtaining a sample and then determining the level of at least of 10 markers that you see listed there on your screen. And all of those are lipid biomarkers. And one of the things the specification says is that detecting at least 10 or more of these biomarkers has high diagnostic value for detecting breast cancer over just using a single marker. So panels of biomarkers can be really useful for getting broad coverage. It's also very important to include kind of the story behind your panel of biomarkers in your application to try and increase the likelihood that you'll get that type of claim allowed. Another recently issued patent from earlier this year, you'll see a little bit different here. It talks about a method of detecting protein biomarkers in a sample in a patient suspected of having a traumatic brain injury or an intracellular hemorrhage. Here we see that the particular claim limitations recite detecting at least four specific biomarkers. But more importantly, it also talks about contacting the sample with a detectable binding agent and then detecting specific binding between that binding agent and the biomarkers using a detection assay and some controls. So again, very specific claim, even though you do have a judicial exception recited in the preamble, you'll see the specificity in the body of the claim in terms of reciting very specific biomarkers and the concept of detecting or contacting that sample with a detectable binding agent that specifically binds to those biomarkers. In another patent that issued just in June, this one is interesting as well because it also has the judicial exception recited in the preamble with respect to determining a gynecological disease state. And you'll notice the first part of the claim talks about obtaining a sample from the subject, but really where the applicant or the patentee was successful in overcoming a 101 rejection here was by reciting specific types of solid supports, here a nanoparticle immobilized MgL that was used to form a CA125 complex. So you'll see the claim specifically recites assaying the sample using that specific nanoparticle immobilized MgL, measuring the level of CA125, comparing that with a control or predetermined threshold, but then finally determining a very specific type of cancer, an epithelial ovarian cancer. So really here, the trick and what was successful for the applicant in getting over 101 was the use of a very specific reagent, the nanoparticle immobilized MgL, and the recitation of a specific disease state, epithelial ovarian cancer. And then finally, an example of a case where a treatment step is added to overcome a 101 rejection. Here, a method of predicting whether a cancer patient is going to respond to a certain combination treatment. That combination treatment was an HDA-C6 inhibitor or a proteasome inhibitor. And the method here involved determining expression levels of certain genes, and they're specifically recited, and then correlating low expression of some of those genes or high expression of other of those genes as an indication of whether or not the patient would respond to treatment. And then ultimately administering that combination treatment of an HDA-C6 inhibitor and a proteasome inhibitor. And you can see here that the correlation of the high and low levels of the gene expression in combination with the treatment step is what was helpful in getting this claim over Section 101. But just a note here, you just need to keep in mind that if you're going to enforce this type of claim, you might have a divided infringement issue because of the party that's actually doing the measuring of the levels of expression and the correlating might be different than those administering the combination therapy. And with that, I would like to turn things over to Noel, who's going to talk about Canada.
Thank you very much, Lisa. That was a very helpful presentation. And thank you to the Dehns firm for having us participate in this seminar. I work with that firm a fair bit and a very solid, reputable firm in Europe if you need a hand with diagnostics or other technologies. So I'm going to give an overview about diagnostics in Canada. And firstly, as far as diagnostics go, there are a couple of hotspots in Canada. Firstly, diagnostic methods that are performed that involve a step of treatment or diagnostics on the body. And secondly, certain molecular diagnostic methods also are having issues with patentability. So we're going to talk about those and ways to address the issues in Canadian practice. So first of all, diagnostic methods performed on the body. This is a bit of an issue because if you have a step that involves sampling or scanning a person, then that is considered to be unpatentable as a method of medical treatment. So the solution is to omit the step performed on the body if possible. And use claims can often be inserted as an alternative to protect these types of diagnostic methods. So you don't have a method step, you have a use for treatment. As far as the molecular diagnostic methods, the issues there in Canada began with a high-tech decision that came from our courts about patentability of subject matter. As you are probably aware, there are plenty of issues around subject matter and software. This case involved Amazon, which had a one-click patent. The steps for subject matter assessment set out by the court were to do a purposive construction of claims, which means to divide them into essential and non-essential elements. Then you determine the subject matter eligibility and look at what the essential steps are that you've picked out of the claim through your purposive construction. So this, as I mentioned, came up in a high-tech case involving an e-commerce method, but The Canadian Patent Office put out a practice notice after the Amazon case dealing with high-tech situations, but also a practice notice that effectively sideswiped certain types of diagnostic claims. It was a very broad expansion of what that court case was about. Effectively, they said that we're going to classify into two types of inventions. Inventions that fall as being data acquisition will be acceptable subject matter. So things like novel analytes, meaning reagents, biomarkers, etc., or a means of identifying, quantifying an analyte. So if you had a new device involved, if you had something specific in the detection methodology, you might fall under the data acquisition stream. If you are simply doing what they characterize as a data analysis, for example, a new correlation, so think of doing math in your head, comparing a couple of values, the Canadian Patent Office said that that is not acceptable subject matter. So correlations between a disease and a known analyte, they have effectively fallen out of favor with the Canadian Patent Office. And of course, there is a lot of gray area between what you can characterize as a data analysis-based invention or an invention where the essential steps involve data acquisition. So it's been the subject of quite a fair bit of discussion within the profession and arguments with the Patent Office. Again, we don't have a court case setting this out. This is basically Patent Office policy derived from the Amazon high-tech case. So to look at a simple molecular diagnostics patent claim, you could have a method of identifying a subject with a viral infection who will respond to drug X. Measure the expression of a gene in the blood sample from the subject, and wherein the level of expression of the gene is above a certain threshold, then you know that that patient will respond to the drug. So that's a simple claim and routinely was granted in Canada for many years. But under our current manual of practice, which has incorporated the practice notice on diagnostics, you have to identify the problem addressed by the claim and the solution contemplated by the inventor and the essential elements that are provided. So if the claim is limited to essential elements that are disembodied, for example, a correlation between a known analyte and a disease state, that is considered not patentable by the Canadian Patent Office. And you get a similar result even if you write that in a use claim format. So I mentioned treatments on the body. That type of diagnostic can be objected to as incorporating a surgical step or a method of treatment, or you can phrase it different ways depending on what's happening in that diagnostic. Some are invasive, some are molecular. But if you can write it as a use claim, it gets you over that hurdle. That's not the case with this type of invention we're talking about here, where it's phrased as a data analysis step or a simple correlation. So what we do in our arguments is we do try to find a way to phrase the invention as being a data acquisition rather than a data analysis. And we try some of the similar approaches that are done in the U.S. So Lisa outlined these types of approaches. As she mentioned, as I mentioned earlier, things like detection techniques, the nature of the sample, specific device, combinations of markers, and adding on a medical use step. So that's something that I've specifically flagged on this slide because in Canada, as in the US, you can have a divided infringement issue where one entity is doing the diagnostic step and another entity is doing the treatment step. So you have to be cautious using that type of approach. A good thing about Canada is that there are no excess claim fees, so you can try various approaches and you can put in a number of fallback positions and you're not going to pay extra for those claims here. So basically, just to summarize, new biomarkers or new improved methods of detecting known biomarkers can be patentable. But if the new discovery is entirely based on a correlation, then there's likely to be an issue about patentable subject matter. Okay, again, CIPO policy, so feel free to argue it. And we are looking forward to getting a test case to go up to the courts to further have this principle challenged and to hopefully improve the lay of the land for diagnostics. So again, thank you to Dehns and thank you to Lisa Mueller for that presentation on the US. And again, I'd like to thank my co-author for the Canadian chapter, Ainsley Parsons. And please have a look at the book. It's a great read. And with that, I'll turn the presentation podium over to Phil.
Okay, great. Thank you, Noel, and thank you, Lisa, for those excellent presentations and very useful presentations as well. I'm going to talk now about the current situation at the EPO for diagnostics. And I say current situation, but actually this has been the situation for some time now. And compared to the US and Canada, things are pretty stable here in terms of diagnostics. So, okay, so in Europe, we talk about patentable subject matter or patentability rather than subject matter eligibility, but we mean the same thing. And patentability is governed by Articles 52 and 53 of the European Patent Convention, the EPC. Article 52.1 states that patents should be granted for any inventions, and there's no definition of what an invention is, but Article 52.2 lists certain things which are definitively not an invention. And some of the items listed in 52.2 are relevant to diagnostics. I've underlined those, and in particular, I want to focus on discoveries. And as we've seen in the US and Canada, most diagnostic inventions, diagnostic methods are based on a discovery, the correlation between the level of a particular biomarker or analyte and a disease state or a clinical picture. That discovery is not an invention according to the EPC. Article 53 excludes further subject matter from patentability, irrespective of whether or not it's considered an invention. And one of those exclusions is diagnostic methods practiced on the human or animal body. So I'll be talking about Articles 52 and 53 today, but the EPO does apply these exclusions quite narrowly. So if we look at Article 52 first, we have to read the exclusions in 52.2 in the context of Article 52.3, which states that the exclusions shall apply only to the extent to which an application or a patent relates to such subject matter or activities as such. And the term as such is the key there. What it means is that while you can't claim the discovery itself, the correlation between the biomarker and the disease state itself, you can still patent inventions that are based on that discovery. And that principle was confirmed in a landmark enlarged Board of Appeal decision, G2 of 88, where the board stated that the fact that the idea or concept underlying claim subject matter resides in a discovery does not necessarily mean that the claim subject matter is a discovery as such. So G2 of 88 had nothing to do with diagnostics, but the reasoning holds, and it means that the situation in Europe is that diagnostic methods are patentable subject matter. So I've set out a summary of the approach in the US and the EP approach, because on paper at least, there seems to be some similarities here. So if there is this discovery underpinning diagnostic inventions, this correlation between biomarker and disease state, the discovery is excluded in Europe, but inventions that are something more than that discovery, inventions that are based on the discovery, are patentable. And in step 2A, prong 2 in the US, the question is asked, is the judicial exception integrated into a practical application? And if so, then there is patent eligible subject matter. So in theory, these things look like a similar approach, but we know that we get very different results, and that the presentation of a judicial exception, the discovery or the correlation in the form of a simple, straightforward diagnostic method claim isn't enough to avoid the exclusion in the US, where it is enough in Europe. And this slide just exemplifies that. This is the independent claim from the 623 patent in the Mayo Prometheus case, which Lisa mentioned, and the equivalent claim in Europe. So the claims of both cases are directed to a method of optimizing or determining efficacy of treatment of an immune-mediated gastrointestinal disorder. And both methods are based on exactly the same correlation between the level of a biomarker, 6-thioguanine in a subject, and the subject's responsiveness to treatment. So that claim was, of course, deemed patent ineligible in the Mayo decision, but a very similar claim in Europe, based on exactly the same correlation, was allowed by the EPO, and that claim would still be allowed today. So the EPO is much more pro-patentee for straightforward diagnostic method claims, but we also have to look at Article 53 as well. And Article 53C expressly excludes diagnostic methods practiced on the human or animal body. And again, this exclusion is also applied narrowly. To fall within the exclusion, the claimed method has to be both diagnostic in nature and practiced on the body, and I'll look at both of those requirements in turn. So there's no definition of what a diagnostic method is in the EPC, but there was a landmark decision, again in large board, G1 of 04, that defined a diagnostic method as comprising at least the following steps. An examination phase or a data collection step, then the step of comparing that data with standard values or a control, the finding of any significant deviation during that comparison, and finally an actual decision step where the deviation is attributed to a particular clinical picture. And this is the definition of a diagnostic method that is applied by the EPO today. So this makes technical sense. A diagnostic method does usually contain all of these steps, and it raises the obvious question, which is, can you avoid an Article 53C exclusion by presenting a claim that omits one or more of these steps? And the answer is that yes, you can sometimes. So if you that recites only step 1, which was the data collection step, then the method is directed to a method of data acquisition. It's not considered to be a method of diagnosis. If you present a claim reciting all of steps 1 to 3, but omitting that key decision step where the deviation is attributed to a clinical picture, then the method will be considered to be a method for providing an intermediate finding of diagnostic relevance rather than a diagnostic method. And so those claims are allowed, even if they're practiced on the human or animal body, because they're not diagnostic methods according to G1 of 04. And as an example, there was a claim in Board of Appeal case T1255 of 06, which was a method of determining ear temperature. Now, this was clearly performed on the body because it involves inserting an extension into the ear. But because the ear temperature was not used to decide on a clinical picture, then the claim is either a method of data acquisition or a method for providing an intermediate finding of diagnostic relevance, but it's not a full method of diagnosis itself. So this claim wording is acceptable. Just a word of caution though, if you go down this route, you have to ensure that your claimed method is not, as well as being not diagnostic, is also not surgical in nature and is not therapeutic in nature, because if we go back to Article 53C, methods for the treatment of the human or animal body by surgery or therapy are also excluded. So you need to avoid those exclusions as well. Back to the steps that you could choose to omit. In theory, you could choose to omit data collection step 1 and just recite a method comprising steps 2 to 4, which is performed on data that has already been obtained. So the method doesn't recite the actual data collection step. Now that won't be considered a method of diagnosis according to G1 of 04, but you need to take care with that sort of claim, because steps 2 to 4, the comparison, finding and decision steps, are all arguably mental acts. So the method as a whole will be considered to be a method of performing a mental act as such, which is excluded under Article 52.2 as a non-invention in Article 52.2c. But in theory, that claim format is available. So omitting some of steps 1 to 4 from G1 of 04 is definitely an option, but there are some cautionary tales. So the EPO assesses added matter very strictly and requires any claim subject matter to have been disclosed in the application as filed. If you present a claim during prosecution that lacks some of the steps, and claims lack, or a disclosure of a method lacking those steps was not made in the application as filed, then you're likely to run into added matter objections. And that's exactly what happened in this case, T143 of 04. In this case, the claims as filed were directed to a method of diagnosing Alzheimer's disease, and the method was deemed to be an excluded diagnostic method practiced on the human or animal body. The applicant tried to overcome that objection by amending the claims so that they were directed to a data collection method, not a full diagnostic method. But the application as filed didn't actually describe a data collection method that was distinct from a full method of diagnosis. And so the board rejected those claims for adding matter, and the applicant was stuck between these two objections. So the key is to make sure that you include the methods lacking certain steps when drafting. There are some other traps you can fall into as well if you're omitting steps. If the steps are deemed essential to the performance of the method and the achievement of the technical effect, then you risk objections for lack of sufficiency, clarity, or support. And if certain non-recited steps are considered by the examiner to be nevertheless implied despite being omitted, then they'll still be considered as present, so you haven't really omitted them. So for instance, a lot of diagnostic method claims will recite the data collection step and the decision step, but they might not expressly recite the comparison and the finding of deviation steps, but they will still be considered to be present. So omitting steps 2 and 3 alone doesn't really get you anywhere. But anyway, the message there is that omitting step 1 and definitely omitting step 4, if you have basis, is a viable option for presenting a method that is not considered truly diagnostic, and so avoiding the exclusion. If your method is diagnostic, then it's very easy to fall within the other side of the exclusion as well, because what's considered to be practiced on the human or animal body is pretty much any interaction with the human or animal body. And the way the EPO assesses it is to consider the technical steps of the claimed method, which in all likelihood will be the data collection steps. And if there's any interaction with the body, then it's practiced on the body. So those steps, those interactions, don't need to be invasive. They don't need to involve any risk to patient safety or require a medical professional. Those sorts of considerations are taken into account when considering if a method is a treatment by surgery, but not when assessing if a method is practiced on the body. But of course, what this means is that you can present in vitro or ex vivo diagnostic methods because they aren't excluded, because they aren't practiced on the body. So you could also recite that the method is performed on a sample that has been obtained from a subject. Don't recite the active step of taking the sample, because that is obviously very likely to be practiced on the body or even surgical in nature. And although it's good practice to include this in vitro ex vivo wording when drafting, the EPO is actually pretty permissive about allowing you to amend claims to recite in vitro and ex vivo, even if there isn't basis in the application as filed, because they are undisclosed disclaimers to avoid an Article 53C objection, and that's one scenario where basis isn't required. So this is basically a summary of what I've just said, the EPO exclusion flowchart for diagnostic methods. So we don't really need to worry about Article 52.2 because the diagnostic method isn't directed to a discovery as such. And then in terms of Article 53C, there are 2 routes to avoiding the exclusion. Ask whether or not the claim is for, these are the steps from G1 of 04, And if not, and provided the missing steps aren't essential to the invention, then you avoid the exclusion because the method isn't diagnostic. If those steps are present, then consider which of them are technical in nature. And if they're not performed on the body, then you avoid the exclusion. So if your method is excluded under Article 53C, then you might still have some options for claim language. Because Article 53C, which says that diagnostic methods practiced on the human or animal body are excluded, also states that the provision shall not apply to products, in particular substances or compositions, for use in any of these methods. So this allows the use-limited product claim format, substance X for use in diagnosing disease Y in vivo. Now, this claim format is used by the EPO and some other patent offices as well, but it's more commonly seen when the invention is a method of treatment by therapy. So method of treatment claims, method of treatment by therapy claims aren't allowed at EPO. And so those claims will be recast into this substance X for use in a method of treating disease Y. But this claim format is also available for diagnostic methods that are practiced on the body. When two conditions are met. So first of all, the recited use has to be a use which would be excluded if presented as a method claim. So it's important to set out in the use part of this claim that the method is not an in vitro method and that it is a diagnostic method. And the second condition is that the substance that's being used for use in diagnosis here is a chemical or biological substance, not a device. It's a slight grey area of EPO practice. If the device comprises a chemical or biological substance which performs the detection in the diagnostic method, then you may be able to recite a device within this claim. But as a rule, this claim is for chemical and biological substances, not for devices. And that's a small bone of contention because Article 53C basically allows this format for products, in particular, therefore not limited to, but in particular, substances or compositions. But anyway, that's a minor point. So in summary at EPO, diagnostic inventions that are rejected as patent ineligible in the US are usually still patentable. Diagnostic methods that are practiced on the body are excluded, but you need to have both of the highlighted features there to fall within the exclusion. So you can present claims that lack some of the steps of G1 of 04, if technically appropriate, to avoid that exclusion. Make sure there's basis in the application as filed and that the claims do not comprise surgical or therapeutic steps as well. In vitro diagnostic methods are unproblematic, and for in vivo or in situ diagnostic methods, you might be able to use the use-limited product claim format if the product is a chemical or biological substance. And that is a summary of the situation in Europe, and that brings this webinar to a close. I'd like to thank Lisa and Noel again for their presentations, which are very useful. This is one of the most difficult areas of our practice at the moment. So it was really good to get such detailed talks with take-home practice tips for us to think about. And thank you all for listening as well. As I mentioned at the start, you can send questions either to us by email at these addresses or using the Q&A box within Zoom, and we will get back to you. So thank you again, and goodbye from all of us.